Chairman, with respect, thank you for the opportunity. Let me first respond to the issue raised by the respected majority leader, which issue he anchored on Order 103F. For the avoidance of doubt, I would repeat the provisions in the said order. A motion shall relate to a definite issue and not be the subject matter of an action on which judicial decisions is pending in such a way as may, in the opinion of the Speaker, prejudice the interests of parties to the action. These are my views on this. First of all, we are not dealing with emotion. But granted that, as he put it, this provision that deals with conditions of admissibility of motion should be read and construed within the context of my preliminary comment, then I would even yield to that and then ask a question. Was he not the same person who, when the minority brought a matter up on the floor regarding the mass dismissal of public sector employees, he came out with the preliminary objection to the fact that the matter was in court. Henry Nana Boakye has filed a suit at the Supreme Court. Therefore, Parliament should not even discuss it. Whereupon, the Speaker upheld his objection, in spite of explanation to the fact that the matter had nothing to do with the suit in court. Now, even today, now he says that my reference to cases pending at the ECOWAS court, at the Supreme Court, at the High Court, amount to prejudicing the outcome. Really? But we have a nominee before us. The nominee with the power to empanel. In fact, the empaneling of the court for the determination of injunction application was done swiftly. As we speak, per his own words, the court has not empaneled the Supreme Court to determine the substantive matters before it. Recently, we heard the Attorney General even applying to the court for leave for extension of time to file a defense. We have a nominee before us with the power to empanel. He has not empaneled. If we are now interpreting 103F properly, then it rather even applies to the case of the minority that this matter should be placed on ice, because the nominee is likely to be conflicted, especially when he is the one to empanel. Two, that the substantive matters have not been dealt with.
Honorable
So
Minority
let
Leader,
me finish.
with all
Chairman,
due respect,
you allowed the minority leader. I'm responding to his
not asking
objection.
the Minority Leader to raise an issue. Order.
I am responding to his, I'm responding.
Honorable Minority Leader.
Let me respond.
Honorable Minority Leader, hold it. Honorable Minority Leader, hold it. May your microphone be off, Minority Leader.
Chairman, just a second. Bear
Minority
with me.
Leader,
Chairman,
let your microphone be off. Hear
Chairman,
me out.
Very well. I will hear you.
Yes, I'm
and then
supposed
continue my
to
argument.
play the fair game here.
If you make your point, we respond.
Honorable Minority Leader,
What is wrong?
please, just
don't have to
observe
respond.
me.
The Chairman spoke.
Hear
for
what I
almost
will want
20
to
minutes.
say. Honorable members, can there be an order? Order. I don't want to hear anybody's voice again. Honorable members, when an objection is raised, I listen to the objection. So I expect you to respond to the objection that is raised. I don't think in all the objections raised, there is anything in the objection that suggests that the nominee before us swiftly empaneled, acted in conflict. I mean, all those things have not
You've said
been-
that. You've said that. You've said that.
Why?
You've said that. You said that. You said that the nominee
So-
swiftly empaneled a court.
So, honorable members, on this note, I would want him to conclude. I will rule on the matter, then we take a short break and come back and continue with the vetting.
Chairman, with respect, it is my view that if the order 103F that the majority leader made reference to at all is applicable, then it is the more reason for the minority's concerns to be heard. Here is he suggesting that nothing should be raised that is likely to affect the outcome of a pending suit. That is what he says. He says that my reference to matters that are pending before court amount to a situation where I will be offending Rule 103F. If that is the case, then the matter before us is rather more fitting than the argument he's making against me. Because, with respect, we have pending suits for over 6 months.
Chairman.
No, I have the floor. You've not called me.
Chairman, the rules.
You have not called
the
him.
rules.
Chairman, you
the
see,
rules.
Chairman,
the rules.
Chairman, he puts
the
on the
rules.
rest.
The rules are clear.
No, it's not.
The rules are clear. The rules are clear. Chairman, the rules. Though when you
Just comes in. But you just put on your microphone and speak. Leader, you just put on your microphone and speak. That's all right.
Honorable members, I have stated clearly, the whole world is watching us. You will not have the floor until I ask you to do so. I will consider a situation where you put on the microphone without the speaker asking you to say something as disorderly, and I will invoke the rules appropriately. So we should all take note. Minority Leader, kindly conclude.
So, Chairman, what I am saying in short is that the very rule that the majority leader is invoking supports the contention of the minority. And I'm responding to him by saying that the cases that are pending, that he has a problem with my earlier statement, if we consider this motion, they shouldn't forget that what Parliament is doing, the vetting of the nominee, eventually will lead to the report being moved on the floor.
Honorable Minority Leader, hold it there.
For him to come in?
Yes, hold it.
Okay,
Not for him to come in. I am coming in personally. Severally, I admonish you that a matter that has been dealt with on the floor of Parliament, this vetting committee cannot be constituted into a court of appeal to reverse any decision. Therefore, I will personally not tolerate any of those issues to be read. Now, I accommodated the majority whip, and he read in extenso your motion. So anything that relates to your motion would not be entertained before this particular committee, because for me, that matter, procedurally and legally, is mute. It cannot be raised. So, Minority Leader, kindly conclude.
Chairman, there are two issues that have been raised, and each of them must have a response.
When your leader is speaking and you're asking me to give you the floor.
The majority leader has raised his issue. And then the Afenyo-Markin also brings in a different issue. So I'm done with him. Let me now address the Afenyo-Markin's issue, the majority chief whip. The majority chief whip is contending that the minority's motion was ruled upon. Mr. Speaker, Mr. Chairman, we are not here to rehash our argument. We have not brought any argument before the House. We filed an administrative motion, which motion was declared inadmissible. It's as simple as that.
You have to catch the attention.
Now, it does not stop us from stating our views on an important national matter. It doesn't stop us. We are not challenging the Speaker's ruling at this committee. We know what to do. The minority, even when we disagree with the First Deputy Speaker, filed a review application which was admitted, and we started a debate. We are not in any way against any ruling and against any rules. We will use the rules to express our views. So the majority chief whip is completely wrong to introduce that matter. What we are rather saying is that the rule that the majority leader is seeking to invoke to rather stop the minority from exercising its right of opinion on a matter of national importance rather supports the very reason why we had come with a motion to say that let all the matters be determined to bring clarity, because her ladyship, Justice Arabe Esaba Tokonu, has rights, far right. And what becomes of her when eventually the court determines that all her reliefs are upheld, yes, and then what becomes of us?
Yes.
What
Honorable Majority Leader. Honorable Majority Leader.
You are hearing him?
No, I am the one speaking.
What do you want?
You understand?
Yes.
Please, let's take a cue. Severally, I admonished
Him or me?
that everybody, that anything that has to do with a matter raised on the floor and a ruling delivered by the speakers, including me, would not be entertained. So that one, strictly, any attempt to go into that particular area, I would ask you to stop your submission and maybe go to another area. And probably we may have to take a decision if persistently you've decided not to listen to the chairperson of the committee. So I am pleading with you. You see, with Jerry Ahmed, you catch the eye of the speaker at the right time. You don't expect me to interrupt the minority leader to give you the floor to speak. It is not done in any parliament. So minority leader, if you are done and you want me to make a ruling, I will make a ruling. Then we take a break.
Chairman, with respect, the minority on this committee is ready to assist you through this process. It is clear to us, however, that consistently there is a grand design to obstruct us, deny us of our right to express opinion on a matter of national discourse. We are clear on our minds what the majority is up to. And Chairman, although we know, and it's a fact, that all of you are of the same stock, we, however, think that we should be heard. All these objections that they are raising here and there has one aim, that the minority must not be heard for posterity. They know that if these views get into Hansard, it will come back and haunt them someday. That is all that they are doing. Chairman, it's not a matter for ruling. I hold a view on behalf of my colleagues that you should restrain the majority leader, because it is one too many, very consistently, the statement that I made as part of my remarks that he is invoking Order 103F is neither here nor there. I didn't make any prejudicial comment. I didn't say anything that offends Order 103F. It is very clear what he is up to. Let us be very fair. Let us allow democracy to be at play. They are in the majority, no doubt. They are in majority, no doubt. But they should allow us. I'm responding to, you see, Chairman, Chairman, what the majority leader is doing, is not fair. He raises his issues. You don't have to respond. When you are responding, he now determines how you should respond to him. The chief whip has spoken. You have spoken. When you are talking, you don't calculate the hours.
Because
Honorable members, order.
When you are talking,
Order.
When you are talking, you don't talk about the
on
time.
this note, we'll break for cocoa. So it's time for cocoa break.